Thank you, Chair. We're live on YouTube and the meeting is being recorded again.
Okay, welcome back, everybody. Just a reminder, we will be, if we need to, we'll be here and stopping at 4:30. So, are there any other interested parties who haven't spoken before who wish to address the committee? Okay, we have one.
Oh, sorry, Chair.
We need to do a roll call, don't we?
Members, yeah. So if I just read out and
okay, we'll just do a quick roll call to check that the 3 committee members that I can see on my screen at the moment are here for the benefits of procedure.
Okay, so Councillor Bloxham.
Present.
Councillor Chapman.
Present.
And Councillor Wibley.
I am not here. No, I am present. Sorry, my mistake. Okay, so yeah, if any interested parties who haven't yet spoken wish to raise their electronic hand or wave frantically at the cameras, now is the time to do so. We have one interested party at this point. John
Mary
Seeley.
Mary Nash.
And Mary Nash, that's fine.
Chair,
So
Chair,
John and then Mary.
Sorry to interrupt, Chair, could you just check that the applicant solicitor is with us?
Oh, yes. Mr. Pinwell, are you here?
I'm still here, Chair.
Lovely, thank you.
Brilliant. Okay, Mr. Seeley.
Hello, Chair. Can you hear me?
We can indeed.
Great. Thank you very much. Many of my points have actually been very well covered already. So just very, very briefly, because I have to go shortly, if I could just cover what I have to say. This is as a concerned resident. I'm not a councillor. I walk past the Water Sports Centre on most days, and I've taken a great interest to see it develop and take shape over the past few years. I've kept abreast of many of the reports and any of the information about how the centre might develop. There's been much talk about the patisserie, for example, bringing a little bit of Paris to Exmouth, much anticipation of Mickey's restaurant, and also how Sideshaw will distinguish Exmouth as a leading water sports destination with various water sports attractions. But there's never been any mention that I'm aware of it being a late night drinking establishment. All the rest is great. I'm very much in support of it, but I've not read anything about it turning into what seems to have come out of the blue. And I think anyone could be forgiven for thinking that any centre wants to stay open till 2:30 every night of the week does indeed appear to be more of a nightclub, which was not at all what we thought we were getting. For the centre to stay open until those hours, I think it's both unwarranted and it's unnecessary, so not justified and not needed. I think people leaving at 2:30 are likely to be full of bravado and very tempted to take a swim in an area which has already been discussed, has very strong currents. At low tide, it's very tempting to try and swim across to Pole Sands. And at the very least, I think there will be a certain amount of noise and disturbance and possibly damage occurring as the late night drinkers make their way home at 2:30 in the morning. So essentially, I think the application is likely to create issues that did not previously exist. And the fact that this was supposed to be a water sports centre, not a late night restaurant, has left me with concerns which have been very well covered by some of the previous speakers. Thank you, that's it.
Thank you very much, Mr. Seeley. Does either any members of the committee or Mr. Pinwell wish to respond to that at all? No, okay. Thank you very much, Mr. Seeley. Mary Nash, do you wish to speak? You are next.
Trying to unmute by the looks of it. Chair, perhaps you've got another speaker.
Oh, yeah, didn't see that.
Metcalfe. Might just be worth giving Ms Nash a moment to.
Oh,
no. Oh,
there we go.
Right.
I think I'm okay now.
You are, yeah.
Just very briefly to reiterate many of the things that were said before lunch. Just nobody had specifically referred to wind direction when it comes to sound travelling. And I live in Trefusis Terrace, immediately to the north of the building, and most of the complaint, or most of the people raising, having representations, are also people who live to the north of the building. By definition, that's where we all live. The prevailing winds are southwesterly. There is a mention in the applicants, in the application, that they are facing towards the sea. They're facing towards the sea from where the winds, I would say 90% of the time, the wind is coming towards us from the sea, because that's the direction of the prevailing winds. It is unusual for us to have northerlies. It is very common for us to have southwesterlies. That was all I just wished to point out to the Mr. Councillor Whibley and the members of the committee. Thank you.
Thank you very much. Do you have any responses to that from either the committee or Mr. Pinwell?
Nothing from me, Chair.
Okay. Thank you very much. And we have another interested party, Carol Metcalfe. You're on mute. There we go.
Hi. The Environmental Department has actually addressed the issues of sound nuisance, potential nuisance to the residents nearby. What hasn't been addressed to date is the vibration, the effect and passage of vibration to those residents in the area. Having lived in London, in southeast London, near the Ministry of Sound, I can assure you that loud beat music not only communicates across areas in terms of sound, but also the vibration can be felt in buildings. And I would be pleased to hear the comments from yourself or the Environmental Department on this issue, please.
I don't know, is Alice still here?
She is, yes, Chair. She's on mute at the moment.
Are you able to help us with this, Alice? I do remember reading in the sound report about particular frequencies, like bass frequencies, being limited in a particular way. But I don't know if you have any further comment.
Yeah, we have accounted for that in our third condition, which talks about the lower frequency levels, so that be accounted for. So any bassy noise has to meet the same kind of requirements as the other mid-range aspect of the music noise as well. So that is accounted for. I hope.
Okay.
Thank you.
Okay, thank you very much. Do we have any? Thank you, Carol. Do we have any other? Do we have any other interested parties? I see no electronic hands. Any real hands at all that I've missed? No. Okay.
No, can't see anyone.
Right. Well, that brings part 2 to an end. Okay. So now we will hear from the applicant solicitor again to make a final statement. Yeah. So, Mr. Pinwell, if you are able to sum up for us your position.
Certainly, Chair. I think there has been a full and frank discussion of all the issues raised by local residents before you today, so that those can be aired and potentially dealt with. Obviously, the application has to be considered against the licensing objectives. And if I can briefly run through those and just address the committee. Protection of public nuisance. Noise was a significant issue for local residents, and I can appreciate that. I think you've heard from our acoustic consultant in the report and your own environmental health officer that there are conditions imposed that are robust to deal with this issue. And if we do not comply with the issue, which we severely doubt that we will, then residents have the means to hold us to account. You're imposing conditions of a recognised standard to address issues of noise. I've heard lots of evidence from residents about public nuisance and antisocial behaviour in the area. And a link has tried to be made that as a consequence of that, our premises may exacerbate that due to its late hours of opening. I would say to you that wider antisocial behaviour outside of our licence area is not the responsibility of the applicants. The responsibility of the applicants is, if it is granted a licence, to operate within its conditions, including the monitoring of people at the establishment, including asking them to depart in a quiet and orderly way. But we have no possibility of affecting the wider antisocial behaviour. There is talk about people leaving the premises at a late terminal hour and causing nuisance and disturbance. My clients will have a full and robust regime in place in order to ensure that patrons on the premises are behaving properly, are not unduly inebriated, and they will be asked to leave the premises in an orderly way. Mention was made of polycarbonate glasses and bottles being taken from the premises. As part of our clear operating regime, anybody with one of those items will surrender it before they leave the premises. So we don't consider that is an issue. Many of the objectors have told you should look at an informed risk as part of your policy. So I say, what is the informed risk? You have no police objection to the application. There may be wider antisocial behaviour not linked to the premises already existing. We will operate strict policies to ensure we are an appropriate occupation, and therefore the risk of public nuisance emanating as a result of the operation will be minimised. In terms of the prevention of crime and disorder, I've heard comments of crime and disorder in the area, antisocial behaviour, but that is not attributable to our property. There is an assumption that our property will add to that situation. I say to you, at present, that assumption is unfounded, and with an appropriate licence and robust enforcement of conditions, we can operate the premises so that we do not contribute to crime and disorder and actually prevent it. There is talk of public safety. Much has been made of the environment in which the premises are situated. Our responsibility is for public safety when members of the public are on our premises or the licensed area, and we will take those responsibilities very seriously. I would say to you that the wider public interests and public safety arising due to the proximity of the premises to the beach and the river is not something that you should take into account when considering our license. There is a further licensing objective relating to the protection of children from harm. We will have appropriate procedures in place. There will be ID checking to ensure that minors are not able to access the premises, as is normal in any licensed premises. We will also have strict regimes enforced for the marquee so that children cannot wander from the marquee into the main building. I was asked a question during the presentation about toilet provision for the marquee. I've been able to check with the clients, and the clients are proposing a portable toilet solution on the marquee so that everyone attending an event will use those facilities, and there will be no need for children or minors to enter the main building. Finally, the terminal hour applied for at the premises. We have applied for 2 AM for the sale of alcohol and the other hours set out in our application. This has given rise to representations from the public that it is too late. I've already outlined to you the provisions of the Ocean license that quite a few residents have drawn attention to as being an appropriate yardstick. I would say to you that that license is now 8 years old. Our clients are trying to establish a venue which will have an attraction and bring an investment to Exmouth. We are applying for a 2 AM license, so we have the flexibility to operate. As I have said in my presentation, it is not our intention to operate that late every night of the week throughout the whole year, but to operate a venue such as this, we consider that that is the appropriate terminal hour we would request from the council. I can see no infringement of the licensing objectives that that terminal hour would give, and clearly with a venue that hasn't opened, there is no evidence as to the nature of its operation. If I go back to the informed risk concept that was mentioned by residents, I think if you look at the nature of the application, the way we have dealt with the council, the police and acoustic issues, this is a responsible operation that has requested a terminal hour which is commensurate with the type of operation it wishes to be. And I would respectfully suggest that you should grant the application as we have applied for it. Thank you for listening to me.
Thank you very, very much, Mr. Pinwell. Just quickly before you go, Councillor Bloxham, did you have another question? Did you have a question? Was it regarding furniture, or has that been answered?
Thank you. I asked Mr. Pinwell at the early stages to clarify whether the event space would have mobile or fixed furniture, and he was going to refer to his client and come back to us.
Am I mute?
You are muted, Mr. Pinwell.
When the marquee is in use, it will have normal marquee furniture in it, very much like you see at a wedding reception, tables, an area for a dance floor. When there is no marquee in place in the winter, there's no intention to place any furniture on the site. I'm sorry I didn't come back to you earlier, Councillor.
That's okay. Thank you very much for the response.
Okay. Right. At this point, I believe, Asita, you wanted to just make a few points before we move to the next stage of the meeting.
Thank you. Thank you, Chair. And it was only to summarise my legal advice and to just mention a couple of other points before you commence your deliberations. I've given legal advice as the committee has commenced, and I'm not going to repeat that, but it has covered things like matters within the direct responsibility of the licensee in terms of conditions, the policy on preservation and protection of coastal and seafront areas and how that sits within licensing, Article 8 of the Convention, public safety, the environmental health conditions. So I'm not going to repeat any of that legal advice, but it's just for your reference and hopefully that's clear. Just, I think, 3 other points. One is the availability of a review mechanism within the Act. I did touch on this, but I'll just repeat it very briefly that at any stage, if the committee feel it is appropriate to grant a licence, there is a review mechanism built into the Act whereby any responsible authority or any other person, i.e. residents, can, if they have the evidence, bring a review of the licence. That mechanism entitles or empowers you to bring the licensee back before you, and you have a range of measures having considered the concerns raised including ultimately revocation of the license. The presence or the fact that that review mechanism is there acts as a safeguard or balance to the flexibility written into the Act for applicants to apply for what they want. It's often referred to as a light touch regulation, in the knowledge that if issues do transpire, if concerns are raised, there is a review mechanism whereby the licensee will be brought back before you. So that's the first point. The second point is just in terms of wider issues of antisocial behaviour and nuisance currently, your policy, I'll just refer you to your policy at paragraph 3.1.7. It's recognised that the licensing function is only one means of securing the delivery of the above objectives and should not therefore be seen as a cure-all for solving all problems within the community. The Licensing Act is part of a wider government strategy to tackle crime, disorder and antisocial behaviour and reduce alcohol harm. The licensing authority will therefore continue to work in partnership with its neighbouring authorities, the police, fire authority, the council's environmental health teams, local businesses and local people towards the promotion of the objectives as outlined. Then thirdly, Mr. Pinwell did mention deregulation, and I should just advise you on the effect of the Live Music Act 2012. The effect that is an act which was brought in intended to encourage the performance of music at licensed venues. That's what that act is about. The effect of the deregulatory provisions of that act is that between the hours of 8 in the morning and 11 at night, the performance of live music for up to 500 people or the playing of recorded music, whether amplified or not, on premises which are authorised and open for sale of alcohol for consumption on the premises is not something which is considered a regulated entertainment. That's by reference to amendments to the Licensing Act 2003. Mr. Pinwell did refer you to that, so I just thought I'd mention it. And then finally, on conditions, there are conditions which have been agreed. So there are conditions built into the operating schedule. There are conditions which have been agreed with environmental health and the police. If you wanted to consider further conditions, the place to start would be the model conditions in the licensing policy. I say the place to start. You would have to hear what's being said and consider that, and then I would advise you to look at the model conditions which are in your licensing policy. You have heard a number of points made. I'm not going to cover all of them, but there was a point about children coming through the bar, which has now been met by a comment with regards to portable toilets being available outside, the marquee being removed outside of the summer months, April to October. Outside of that, no marquee. There's been reference to a noise management plan, reference to monitoring of outside areas, reference to signage with regards to avoiding swimming if you've been at the premises, particularly late at night, reference to people taking drinks out onto the beach, reference to fixed furniture, which again Mr. Pinwell has responded to. My advice is you consider all of that, of course. If you see fit to impose conditions, please have regard to the model conditions which the council has formulated. They're not comprehensive, they're not intended to be, but they're there to guide you if you see fit to impose further conditions. But the test is whether or not conditions are appropriate and proportionate. That's what the test is. And your policy at paragraph 6.4 on page 22 makes this point, which is that the licensing authority will avoid imposing disproportionate and overburdensome conditions on premises. And on page 23 says that conditions will only be attached that are practical, achievable and appropriate for the promotion of the licensing objectives, and if covered by other legislation will not be recovered here. Sorry, the other one that was mentioned was biodegradable vessels, but the point there is about taking them off the premises as much as anything else. So those are the tests to apply to conditions. That is my legal advice at this stage. As I understand it, you will then deliberate now without my assistance, but if I'm further required, I'm available to give you legal advice, which I can then summarise as necessary to those who are here. Thank you. Oh, and sorry, the final thing I should say is if anyone has any comments on my legal advice, it would be helpful to hear it now.
Okay. Is there anybody who wishes to comment on that? I see Michelle Ward, you have your hand up.
Yes, it was before you asked for comments on your legal advice. It was more for a point of information, please. Going back to the fixed furniture in the marquee, a dance floor was mentioned. If that's to be fixed for 6 months of the year, is there any information whether that dance floor will be used at any other time than a private event like a wedding? Or is there any plans for a regular weekend disco, for example, to take place in the marquee? Something we don't know about at all.
Mr.
Can anybody help?
Are you able to answer that, Mr. Pinwell? I mean, it doesn't form any part of the application to do that, so one would hope not. But
from my knowledge with the client, it's intended to use the marquee for booked events like weddings, christenings, and it's not intended to be a nightclub at weekends with flashing lights. It'll be for pre-booked events with patrons who want to have the event there with the food being provided by the premises.
Thank you. That's all I needed to know. Thank you.
okay, thank you very much. Is there anybody else who has any? Martin Heslop.
Is it possible for us just to respond to what Mr. Pinwell said in his summary?
Are we able to do that as to?
Well, that is not within your procedure as outlined, because the applicant has the final word. Having said that, this is a discussion-led process. You regulate your own procedure. It seems to me, as long as Mr. Pinwell gets a final chance to respond, there's nothing to prevent you hearing a further comment. But it really, Mr. Pinwell's summary is meant to be a summary of what's happened, and it is unusual to hear further submissions after that. It's a matter for you, Chair. It's not your procedure, but you do you have discretion to hear something more as long as it's final.
Okay, Mr. Pinwell, are you happy to take that response?
Certainly, as long as I have a chance to respond, Chair.
Okay, that's fine. Okay, then, seeing as it is under my discretion, I would say, Martin, if Heslop, if you wish to respond to that, that's fine.
Well, thank you very much. When speaking frankly, whatever view the committee takes of the noise emissions from the premises and the Environment Health Officer's proposed conditions, which have been agreed, I'm afraid to say and I suspect many, if not all, the interested parties that have made representations to you today have not, I repeat, not had their concerns allayed by the applicants. And we are not encouraged by the proposition that Mr. Pinwell said this afternoon, that it was not the responsibility of the applicant. It's a typical, if I may say so with respect, a blinkered approach, and it totally ignores the fact that the later hours asked for obviously increase the risk of antisocial behaviour and the noise that will create, either by attending or leaving the premises at such late hours. And so we still have no explanation for why they're applying for these late hours, other than a proposition that, well, the Ocean got theirs 8 years ago. Well, so what? The Ocean haven't made an application to extend their hours. What's the reason? And the reason's obvious, isn't it? The commercial advantage that having premises serving alcohol up till 2 o'clock in the morning and premises staying open till 2:30 gives them a real advantage over the other existing premises. And I'm afraid, I repeat, we have not had our concerns allayed about antisocial behaviour and noise created. And to hear it's not the applicant's responsibility, frankly, is just not good enough. And if that demonstrates their attitude, goodness knows what the attitude is going to be in running these premises. And I'm sorry to say that because, of course, we accept that Michael Keynes and his company are responsible operators. But the committee really, in our view, has to have some proper safeguards here to justify why these hours should be so late. And I thank you for listening to me.
Okay, thank you, Mr. Heslop. Mr. Pinwell, if you would like to respond to that, and then we will move on to the next part of the meeting.
I have nothing further to add, Chair.
Okay, thank you very much. Okie doke. So, finding the right part on my bit of paper. Okay, I'd like to thank everybody for being here today. It's been conducted in a way which is which I think has been orderly and succinct, but everybody I think has managed to get their point across, which I think is has helped this process a great deal in terms of us being able to go away and deliberate on this. Just to remind you, what would normally happen at this point is we would go away and discuss this, have a chat, and then come back and read out what we had deliberated. That seems to be what happens in East Devon. Because of the complex nature of this, we will go away and debate our decision, and the all interested parties, so the applicant and objectors, will be notified of our decision within 5 days. So that brings our meeting to an end. Now reading from the script again. That brings our meeting to an end. I'd like to thank everybody, including any members of the public watching online, for taking part. Can I just remind all that those present, all of those present, that the supporting officer will confirm in the meeting's no longer being recorded or going live. And until then, your comments will be live to the public. Thank you very much, everybody.